My lord had allowed this
এটা এক্সটেনশনে আসছে না কেন? দিয়ে দিন, 15 তারিখে দিয়ে দিন বা কালকে দিয়ে দিন। এক্সটেনশন অফ ইন্টারিম অর্ডার কালকে দিয়ে দেবেন। 15 তারিখে এক্সপায়ার করছে না, কালকে কালকে দিয়ে দেবেন আলাদা করে।
My lord, unauthorized construction on the highway in front of my house after past petition, demolition order was not implemented. My lord, again I have filed the petition. Now they are doing it paka on Monday. My lord,
That can be demolished. Next.
My lord, this whole institution of the hearing matter.
Hearing matter, please wait. Lot of matters are already there. Let me finish some then. Yes.
May I tell?
So, for inclusion of the
It will appear.
One urgent motion, urgency is that the entire refund of the petitioner is going to be adjusted against the claim for GST.
Be permitted to mention a matter for obligation. The registration, the GST registration of the petitioner has been cancelled since last year. He is in a hand-to-mouth situation, but he is not being able to conduct his business.
You write that grounds, give it. Urgent motion e diye deben.
May I tell you?
Don't expect it to be listed on the very next day. Don't start mentioning. Keep a watch on the list. All the urgent motions won't appear on the same day. We'll have it in batches.
Kindly mention number 462. But I'm praying that matter may be upgraded because there is an urgency that the income tax authority is issuing notice for garnishing of my bank account.
Bank account diye din. Urgent, yes.
A matter I mentioned in earlier 3 occasions for the last 1 month, the lordship had allowed this. This is a matter where an appeal was directed on the grounds of delay. A recovery notice has been issued. But I had directed this matter to come at urgent motion. However, this matter is coming at item for 434 in today's.
You have mentioned your grounds of urgency. It has not appeared because of your earlier 5 times mentioning, because no grounds of urgency was there in the list. I have already indicated times without number that please mention it, because when I go and check in my chamber, if I don't find those grounds, I will not allow it to be listed as the urgent motion. Please mention it. I will not remember the face then.
Well, I have mentioned my grounds.
very short matter of challenge the circular, which is essentially giving retrospective effect of section.
Circular, please wait. Yes, ma'am.
You find amount is about 9.
You will get it. Once, if you challenge the circular, it has to wait. Yes.
This is a matter of case cash reserve. I'm led by Mr. Bose to expand. Kindly list this point.
Caesar, it's appearing in the list or not appearing? In the list. Yes.
But I'm seeking leave to move a writ petition tomorrow from the urgent determination of Justice Bhattacharya. What has happened, my lord, initially there was a public interest litigation which was filed alleging that there has been
the urgency for tomorrow?
The urgency is this, my lord, without drawing up a 4C proceedings, which the BLRO is empowered to, my lord, they have directly initiated a demolition order. They have directly initiated a demolition. Even if they would have started the 4C proceedings, my lord knows that I have a remedy before the tribunal. I can approach the tribunal. Well, a direct demolition order without granting a single opportunity of hearing, because there was no such direct.
File it, serve them. It can't be taken up tomorrow.
Well,
file it, serve them.
They come back on Monday.
Yes. File it. No leave. You file it, giving date on Monday or Tuesday. I cannot take it, sir. I cannot take it tomorrow.
I'm not.
So you file it in due course. Get the number and mention. File it. Get the number.
File it, and I'm seeking leave. May I come back at 1 PM and hand over the
No,
number?
sir. You file it. Get it listed. When will it be listed? If you file it today, it will be listed on Tuesday.
Tuesday before that bench, my lord.
That bench is not available.
My lord, I have to file it that bench unless your lordship grants me the.
No.
Yes, my lord,
you can always file it. You can always file
No, my lord, I cannot give the number because that is the regular determination. If I give the number, then it will appear over there. Then I have to get it listed and mention before your lordship.
How can you get it listed over somebody else?
Otherwise, my lord, it will not come before your lordship directly, because your lordship does not have the filing determination. My lord, your lordship is only taking up urgent matters. That is the, my lord, with greatest of respect, my lord, what the department says, my lord. If
leave to file. Leave to file, huh? বুঝতে পারছি না কি বলছেন, উপরে নাও। ঠিক আছে,
মানে মানডে
you take leave to file it, Monday you mention.
Your Lordship, may I be permitted to mention for inclusion, Your Lordship?
Lordship,
Inclusion.
এক্সটেনশন অফ ইন্ট্রিম অর্ডার দিয়ে দিন দিদি, একটা 15 তারিখের আছে ওটা দিয়ে দিন, 15 তারিখের কালকে দিয়ে দেবেন কারণ সোমবার 15। Yes.
May I permitted to mention, my lord, the three similar matter, my lord, which are in the monthly list, my lord. Item number 360, 630, 631 and 635, my lord. My lord, there is extreme urgency in the matter, my lord. The petitioner was participated in the 2022 selection process. Thereafter, my lord, their name did not feature in the merit list. They filed before the writ petition, and my lord, there is a order of interim order was there that publish the merit list. Now the situation is the new selection process 2025 already started, my lord. If the seats are fill up, my lord, the petitioner will be prejudiced, my lord. The matter
You
need to
did
be
not
hard.
get an interim order when you filed the writ petition.
Yes, my lord.
When you had filed the writ petition, did you get an interim order?
Yes, interim order to publish the merit list. The merit list of ours published, and we all are qualifying the cutoff marks. We supposed to get appointment, but due to lacuna of the
It's
respondent
a
board,
hearing matter. You mention your grounds of urgency. I don't know. I cannot promise.
my lord,
Let
there
us
is
see.
extreme urgency, my lord. The
For
otherwise the seats
all
are
these
fill up,
years,
my
why
lord.
didn't you mention then?
Yes, my lord.
Why didn't you mention for all these days then?
My lord, my junior mentioned, my lord, but
Junior mentioned before me. Before me, there was no other court available for all these years. From
no, my lord,
2024,
there is a order of interim order that go up to, my lord, Supreme Court. Supreme Court affirmed that order. Thereafter, the merit list published. In contempt proceeding, they have published our merit list. And we find that we all are qualifying the cutoff marks. Thereafter, my lord, the matter was affidavit direction was there after interim order. My lord, thereafter, my lord, the matter is come under the hearing matter. My lord, no other hearing bench is there except my lord. Matlab that's why, matlab,
So let us see when I'll be able to.
matlab
take-
kindly, matlab, otherwise the petitioner will prejudice in
I
spite.
cannot pass order right now. I have
No, no, my
let,
lord. I'm
let
just-
me see. Please
Yes,
don't press
yes,
unnecessarily. Yes.
Your lordship, my senior would mention.
Lordship, may I mention serial 138? It is Lordship that Jyoti Tar matters your Lordship has kept on 17th, two matters.
Yes.
Lordship, one more matter of the same SSC appearing at serial 138. In this Lordship, the notice is under 73, but it is completely vague. One line show cause notice, and we had challenged this. Now they have issued me another hearing notice. Lordship, my junior.
Mr. Kanodia, when those matters are taken up, you mention.
Lordship, kindly sees this hearing notice. He has given the hearing notice
Not
that
now,
if you.
Mr. Kanodia, when the other two matters are taken up,
Lordship,
you remind me then.
Lordship, 15th, he has kept the last personal hearing. That is why I'm mentioning. I have given him in writing that two matters are pending. He has given us a last opportunity. If you don't appear on 15th, I will pass the order.
It's 31st is the outer limit. You cannot pass any order.
Lordship, my junior will hand over the slip.
That is the difficulty. They file it, they do not take any.
So I am upgrading it on 15th. It will appear as an urgent.
Lordship, that is my only humble prayer. Grateful.
15 তারিখে 138 15 তারিখে নোটিশের ডেট আছে 138 15 তারিখে আপগ্রেডেড মোশনে দিয়ে দেবেন ওই যে আজকের লিস্ট যেটা অ্যাপিয়ার করছে আর্জেন্ট মোশন তাতে এটা অ্যাড করে ঠিক আছে
Grateful, much obliged. Grateful.
Yes, please. Yes, I will be indicating a day from next week onwards where I'll be taking up hearing matters. I have indicated that all those matters will appear. Selected a bunch of matters where urgent grounds have been mentioned. Those will be upgraded. Yes. Call করুন জলপাইগুড়িটা কল করুন
Your Lordship, yesterday, your Lordship has similar kind of order. But I am ready to impose the bank guarantee and in terms of 129(1)(a), I am ready to pay that.
That should suffice because penalty calculated in terms of 129(1)(a) he will put in.
Yes.
Rest amount he'll secure by way of a bank guarantee in your name.
Our contention it should be 129(1)(b).
Right.
The rest
So,
of the amount.
129(1)(b) will include a component of 129(1)(a) because it is lesser.
Yes.
Under 129(1)(a), if calculation had been 1 rupee, 129(1)(b) if it is 10 rupees, he'll pay 1 rupee, rest 9 rupees, he'll secure by way of a bank guarantee. So your amount is secured. You will get in hand that other by way of bank guarantee.
My lord, just one thing I need to my lord, draw your lordship's attention. My lord, I am ready to pay the bank guarantee. There is no doubt about that. My lord, kindly turn to page 24. My lord, annexure P2. The amount is, my lord, I have sold the property, sold the goods, my lord, on the rate of 126 per kg, and the total amount.
That you will challenge them.
No, my lord, this is 43. Now they have, my lord, they impose the goods as if it is 80 lakhs rupees. That is the whole difficulty. My lord, they cannot determine it.
Then I will have to determine that I cannot do. That has to be done by the appellate authority, whatever is determined on.
As your
whatever
lordship,
basis,
please. Well, I am not troubling your lordship can pass the order.
because that will be beyond my jurisdiction
Yes,
also as a
yes,
NITCO.
In appellate,
They have taken the total value at 79. At
Yes.
this value, whatever comes for 129 1A, you will pay that.
lordship.
For the balance sum, you will secure by way of a bank guarantee in the name of the respondent.
Lordship.
And in favor of the respondent.
Lordship.
लिखें।
Now it's a short.
Yesterday I WPA dispose of. Yes.
Lord, I am for the petition.
I beg to differ, we have objected.
But very short matter only for consideration of representation by the collector. But the fact is very big. Lord, in 1960, Gazette notification was published for acquiring the land by Chalpaiguri collector. And Lord, huge portion of land acquired, requiring body was the railway. And Lord, the property put to the requiring body. And Lord, in 2015, when I had been asked to vacate my land, then I rushed to the office and collected the all gazette and notifications, and I found that in that gazette notification, my property is not included there at all. But the railway occupied more than 11 acres of land belongs to my predecessors. And what's happened after that, my lord, we made an application and went for correction of record of right. The rounds of litigation was filed, and from all forums, I got the order, and ultimately the railway authority made an application to the collector for joint inspection and for demarcation of the land, which portion is belongs to railway and which portion they did not acquire at all. And Lord, that is why the application was made to the
Where is the application, Mr.
Miller. Representation is at page 93.
1992.
92. 93.
93.
Lord, it will be better, Lord, kindly come to first page 85.
85.
Page 85.
So according to you, your land was never acquired.
Not according to me, my lord. Kindly have a look into page 85. I made an application under RTI Act. The answer is, my lord, as per the record, the award was prescribed under section 37 of DI Act 1962. Available award in the name of Israel Hawk is enclosed. Available award list is enclosed. Information not available. Available award list is enclosed for your reference. Yes. 80. Kindly turn to page 87.
Israel Haq is the petitioner.
My predecessor in interest.
Acha,
87.
You have not been paid the awarded amount.
Yes, my lord. For 2 point something acres of land,
You have been paid.
Yes.
So what is the grievance, Mr. Dolapati, now? If you have
My lord, remaining 11 acres of land, now the railway is going to erect the boundary wall over my property. And my lord,
without acquiring.
Without acquiring. And my lord, kindly come to straightway page 81.
Page 81. Page 81.
Yes.
Yes.
My lord, 11.99 acres of land, they are in possession.
Yes.
And my lord, kindly back to page 77.
77.
Lord, the letter written by Assistant Divisional Engineer, Siliguri Junction. Lord, for joint verification. That verification application is still pending. Verification done, but not acted upon. না ঠিক আছে ওর পরে চল ভেরিফিকেশন হলো রিপোর্টটা কোথায় আছে
And what is your representation for?
Lord, page 93. Lord, the land acquisition collector will look into this issue after giving opportunity of all the parties and hearing to
Look
be
into
made.
the issue of non-acquiring of your land and trying to erect thereon without acquiring, or non-payment of compensation. Which
Lord,
one?
my prayer is, Lord, under direct purchase, as per direct purchase policy, the government
So
will acquire.
your long and short of your argument is that your land without being acquired is sought to be utilized by the railways.
Yes.
So you want that either to pay compensation for utilizing it
Or release my land.
or release the land. This is the long and short.
My lord, in respect of the consideration of the representation, I have no objection.
That is what I will be directing because I will not decide that.
No,
I
my lord,
cannot here. It's a
because
factual dispute.
my lord, the dispute is since 1960.
Well, that is
But I will not take that point. But exact, my lord, this is the, my lord, consideration of the representation, my lord.
the petitioner Unauthorized occupants. Ah. That will be later because today is another day
Your lordship. Good.
and there is no indication that way.
Your lordship, there's no indication.
Yes.
Lordship, for orders, Lordship will take after these batch.
Yes, yes. Whenever your turn comes, because Mr. Kanodia,
Lordship.
Unauthorized Occupants Act, this is only one day.
Lordships.
Yesterday I did not have this in mind.
No,
Later
no,
on I realized, but by that time the order had been passed. So
no worries, Lordships. I will wait, Lordships. No, I will
it's
wait.
appearing in the list as it is, may not be called also today because from 12:30 we'll have original side.
Lordships. Then, Lordships, it will spill over to Monday in that case.
Monday, yes.
Grateful, dear Lords. Grateful.
I'm for the petitioner.
কারণ ওটা ওদের তো চান্স চলে যাবে না হ্যাঁ ঠিক আছে
My lord, I am for the petitioner, my lord. My lord, in front of my house, my lord, there is a government land, private respondents, my lord, constructed.
just let me hear him.
Your he has already accepted on apart from on behalf of the 6, 7, and 8. Just I'm from the past.
My lord, it has been served up 6 months ago.
Why it has been served earlier? Why are you not ready?
My lord, my only prayer, my lord, consideration of representation filed by the district magistrate.
Of the representation.
Yes, my lord.
Attend
And
hearing
not
before-
only that, my lord, after filing of the writ petition, my lord, the BLRO, my lord, issued notice upon the private respondent as well as the petitioner, my lord, and hearing has already been taken place. Kindly see, my lord, please. Let the proceeding be concluded.
Yes, sir.
My lord, I'm showing your lordship, my lord, the report, my lord, as I've submitted in terms of the inquiry, my lord, made by the revenue inspector. My lord, I am so sorry,
Yes, there's
my
no
lord, I have
issues.
only one copy, my lord.
I'll return it to you.
And the map is in the next page.
So it appears that there is occupation of unauthorized occupation of the
My
government.
lord.
So, my lord, let the district magistrate be considered.
All things are. Private respondent 6, 7, and 8 was purchase land construction before on purchase. However, the number 1 question, that is the government property has related with this purchase land. So, my lord, both related, the private petitioners and the private respondent 6, 7, 8. Well, it is a very difficult to assistant, particularly how much has government land acquired by the.
Very well. So I am not going into the merits. The district magistrate will decide the representation. You will also be given a hearing. Whatever you have to say, you say there. Both parties will be heard.
Yes.
Because writ court is not the authority to decide that.
My lord.
DM is the authority. DM will decide that. I mean SDO.
No, district magistrate.
Right?
District
SDO is the
magistrate.
authority. West Bengal public land eviction of unauthorized occupancy. SDO is the authority.
62, my lord.
Yes. SDO. DM is the appellate
SDO
authority. DM is the appellate authority. If the appellate authority considers the representation first, right of appeal will go.
Respondent number
My lord.
4, my lord.
Collector will issue notice, my lord.
See section 7, A and B. It is only for Calcutta. Appellate authority is the DM, B.
Yes.
You've seen it? Huh?
Yes, my lord, let the SDO be considered.
Section 7B.
One.
7(1)B.
My lord.
An appeal from an order made under this act shall lie to the commissioner of the division where the order is made by the collector, and the collector where order is made by an officer specially appointed under subclause B of clause 1 and 2. Yes. So it's SDO for you. SDO is a party here, isn't it? SDO is the party, my lord.
SDO is also the party, my lord. Respondent number
Has to be a party.
Yes,
My
my
lord.
lord.
SDO will. Respondent number 4.
My lord.
Very well. Likun. Who is appearing for the petitioner? None appears for the petitioner. Full stop. No accommodation is prayed for. List this matter under the heading. Now they will appear. Huh? 465? देखिए दीदी 465 है फाइल 465 देखिए এটা কার কি নাম দিলেন দিদি এই নামটা কোথায় নাম তো আলাদা আছে দেখছি yes 11465 of 2023 তাহলে এখানে 25 আছে ভুলভাল দিচ্ছেন এটা 2023 আছে অর্ডারটা কেটে দিন এই জন্য প্রথম দিন ডিসমিস করা উচিত না অর্ডারটা কেটে দিন ঠিক ম্যাটার নিয়ে আসুন লিস্টে এটা লিখে দিন তো একটা অর্ডার রেকর্ড করুন দিস ম্যাটার ইজ রংলি অ্যাপিয়ারিং ইন দি লিস্ট দিস ম্যাটার ইজ রংলি অ্যাপিয়ারিং ইন দি লিস্ট আচ্ছা কিছু করতে হবে কোনটা ঠিক হবে ঠিক করে দিন কোথায় আছে কোনটা ঠিক হবে এই 23 কোথায় করে দিচ্ছেন পরে করবেন
My lord, in this matter, I am for the petitioner. Last occasion, your lordship,
State I'm late by
please to want whether the service has been effected or not. My lord, I have submitted earlier affidavit of service. Private respondent got service has been effected. My lord, where two
উইক ফাইল আনাবেন আগের ম্যাটার আপনি বুঝেননি না বুঝতে পেরেছেন কি বলুন ফাইলটা ভুল আছে কারণ নাম এটা হচ্ছে 11465 of 2025 ওটাতে এই নাম আছে আপনি যেটা দিয়েছেন 1146 of 2020
grateful.
yes
And I am for the petitioner. My lord, only, my lord, it is a very short matter, only for consideration the representation which has been made before the my lord subdivisional officer, my lord Khatal. My lord, what happened, my lord? The petitioner's land, my lord, page 4, my lord, paragraph 4. My lord, petitioner's land my lord, being plot number 765 is adjacent to the, my lord, Rupnaran River, my lord, dam. And my lord, therefore, my lord, the frontage of the petitioner is blocked by some, my lord, unauthorized person by way of constructing Paka structure. And therefore, the petitioner made a representation before the subdivisional officer Ghatal. My lord, kindly direct to the subdivisional officer to consider the representation.
I had directed you to serve upon the all non-appearing respondents.
My lord,
Have all
All-
stayed.
earlier occasion they appeared. Earlier occasion they appeared. Only my lord, state did not appear, and therefore your lordship directed me to serve the copy upon the state advocate. I serve upon the learned senior advocate, my lord.
Upon hearing all the party.
Very well. लिखें the petitioner
হয়ে গেল? (468). Yes.
I am for
My
the
lord, affidavit was filed.
You are for the
60.
My lord, petitioner,
who is appearing for the private respondent?
my lord, copy has been served.
No,
Notice
that
has-
is old affidavit of service. Yeah, before this court, I'll have to check. Unless service is complete, serve again.
My lord,
Although the state
My lord,
respondents are
I am for
represented,
the state bureau's
the
instruction.
On behalf of the respondent.
And I'm for the
Milord-
petitioner.
My lord, first of all, my lord, on the last occasion, my learned friend has, my lord suggested for coming out with the amount which, my lord, so that this can be settled. My lord, my sport is not willing to do that, my lord. So this is the what, my lord, kindly hear out the matter.
Already your lordship heard the matter. What more your lordship will hear? I don't know.
My lord,
I have already completed my submission.
so-
I have said bare that no service has been affected. They have filed two affidavits, one affidavit in the form of report, another supplementary affidavit. In the supplementary affidavit, they have categorically said that they have lost the service. Whether it is lost or not served, I don't know. I have not did, and the service which they have enclosed in the supplementary affidavit, that shows that is not a proper service. So, my lord, if entire thing goes beyond their findings that I am in unauthorized occupation, my lord, what they have indicated, 1 minute, what they have indicated, they have said that initial notice you did not pay the rent. I am ready and agreeable to pay. Whenever they have sent the notice, I have deposited. I have deposited. What more? And moreover, my lord, I am supported by a division bench judgment where our High Court said, if your lordship kindly have a glance to the judgment I have already handed over to your lordship. Yes, that is 2016 SCC Online 4455.
Yes,
Your lordship kindly see the
para 17 you have.
no para 17 regarding the payment. Regarding the payment, the division bench. Yes. Yes. Your lordship kindly come to last part 1, paragraph 25. Under the facts and circumstances, we are of the opinion the matter needs to be considered in depth where several facts can be established. We are of the opinion there is no breathing time for the respondent to deposit the money as directed by the trial court. There the trial court was directed, there is no time. Whether Ballarpur pays the amount due to the due or Ramesh Kumar and Company Private Limited pays the dues, we are not concerned. The facts remains there was to be a proper hearing of the entire matter, not only with regard to the quantification of the arrears of rent as contended by Ballarpur Industries, but also with regard to the rights so-called subtenant as to the inducted Ballarpur Industries and its protection in terms of the other provisions. One cannot ignore the fact the property in question is the public property, and if any amount is due on the property or loss is caused to the port trust, it is nothing but financial loss so far as the public entity is concerned. In view of the above discussion, reasoning, we pass the order. The appellant port trust shall intimate arrears of occupation charges payable by the occupant as on the date taking possession of the property within 2 weeks from the date of receipt of the copy of this order. On receipt of such intimation, 50% of amount shall be due deposited with the appellate authority hearing the statutory appeal. There is no such statutory appeal. That is District Judge Alipur Court within 4 weeks from the date of intimation upon the port trust. Upon deposit of such money, port trust shall give back the possession of the property to the tenant forthwith. This proposal I have made. In state of appellate authority, I want to deposit the entire amount to them. Let them give this, because this is the clear finding of the division bench in a matter where only rent is due. Because subtenancy has not been proved in this matter.
Yes, my lord. My lord, here, my lord, in the judgment, my lord, the question is that the division bench also, my lord, held that it should be adjudicated by the appellate forum, which they choose, even after receiving notice, not to prefer one. And, my lord, in this regard, my lord, I'll refer to a judgment of the apex court, my lord, if your lordship kindly allows me. My lord, this is AIR 2010 Supreme Court 3413. I would refer to paragraph 17 and 8.
I'll come back in 5 minutes.
My lord. my lord, I've referred to that judgment of 2010, my lord, where, my lord, the bank approached against. Yes, my lord. The proposition, the two paragraphs, the ratios which has been laid down, my lord, is paragraph 17 and 18. If my lord, I can place it, my lord. There is another reason why the impugned order should be set aside. If respondent number 1 had any tangible grievance against the notice issued under section 34 or action taken under section 14, then she should avail remedy by filing an application under section 17(1). The expression any person used in section 17(1) is of wide import. It takes within the fold not only the borrower but also guarantor or any person who may be affected by the action taken under section 34. The tribunal and the appellate tribunal are empowered to pass interim orders under section 1718 and are required to decide the matter within the fixed time schedule. It is thus evident, this is very relevant. It is thus evident that the remedies available to an aggrieved person are both under the SURFACE Act are both expeditious and effective. Unfortunately, the High Court overlooked the settled law that High Court will ordinarily not entertain a petition under Article 227 of the Constitution if an effective remedy is available to the aggrieved person, and that this rule applies with greater rigor in matter involving recovery of taxes, sales, fees, other types of public money, and the dues of the bank and other financial institutions. In our view, while dealing with the petitions involving challenge to the action taken for recovery of public dues, etc., the High Court must keep in mind that the legislations enacted by Parliament and the state legislatures for recovery of such dues are code unto themselves, inasmuch as they not only contain comprehensive procedure for recovery of dues, but also envisage constitution of quasi-judicial bodies for redressal of grievances of any aggrieved person. Therefore, in all such cases, High Court must insist that before availing remedies under Article 227 of the Constitution, a person must exhaust the remedies available under the relevant statute. Then paragraph 18. While expressing the aforesaid view, we are conscious that the power conferred upon the High Court under Article 227 of the Constitution to issue to any person or authority, including in appropriate cases any government, directions, order or writ, including the 5 prerogative writs for enforcement of any of the rights conferred by Part 3 or for any other purpose, are very wide, and there is no express limitation on the exercise of that power. But at the same time, we cannot be oblivious to the rules of self-imposed restraints evolved by this court, which every High Court is bound to keep in view while exercising power under Article 227 of the Constitution.
Mr. Dotto,
My lord.
come to the end of paragraph 18.
My lord.
Read just where there Whirlpool Corporation and all have been mentioned.
Yes, my lord.
The sentence beginning with off.
My lord, of course, if the petitioner is able to show that in it case falls within any exceptions carved out in Varam Proprocast. My lord, what is the exceptions, my lord?
Violation of principles of natural justice is the exception. That is one of the exceptions.
My lord,
right from Whirlpool till today.
Miller, till today, you cannot define. Three
out of the
basic principles cannot be denied.
Four. One of them is this. Whirlpool says 4. Principles of natural justice, fundamental right,
audio
ultra vires, and patent violation of statute.
Here, my lord, the 3, my lord, is here, my lord, comes of this 3. One, my lord, he must have a notice. The other is audio altering pattern, and judges like Caesar's wife is above suspicion. This is the 3 which, my lord, the natural justice it is also harping about. My lord is questioning as to he must have a notice, the first proposition. Now, my lord, here, my lord, we tried to serve. That service, when not effected, my lord, we have
your attempt is not satisfactory, Mr. Lord, so last day also I indicated to you, my lord, you had 2 addresses. You
Lord,
had two addresses.
Lord.
One you failed.
Hmm.
Second, you did not try. You went off to serve notice through.
Milord, we have in a supplementary affidavit has specifically stated that we tried, but we have lost the receipt.
That so how can I believe that?
And Milord,
On
what
basis?
about the
There has to
process
be
server,
some
Milord?
basis.
The
What process
process
server?
server got a report that he has
Process server.
tested it on the property.
Where?
Milord, this
Where?
is in the supplementary affidavit.
Where? Show me.
The process server has served it as a, Milord, kindly come to page 6 of the supplementary affidavit.
Yes.
Report of the process server.
Yes.
He has stated that he has pasted it. What is the reason of display? If it is to be displayed, it is by way of evidence. How can a read code supplementary affidavit? That is the report of the process server.
No address has been given.
Milord,
Where?
question is,
Where? That is even where? Where had he served? Where? At which place did he pay?
process servers. But Milord, the notice picks up the address. The notice itself at the address which is there in the
Yes.
read petition itself, the affidavit in opposition itself. The notice shares.
Sir, this report which you are relying on,
Milord,
where is the address where this notice was pasted? Which address?
Milord,
It only
section
states two names.
Milord, this
Page 6.
Milord, kindly comes to the bottom. I,
Bottom.
Ranjan Sarkar, designated process server, went to Srimati at 13:55 p.m. at about 14:12, but failed to serve notice under section 4 or section 7. Now kindly comes to the notice of section 4 and section 7. The section 4, section 7. Milord, kindly comes to that.
All these vague arguments have been raised.
No,
Nothing has been given.
Why
in the
vague?
report.
We have come up with the
Your
document.
lordship has seen specifically indicate I went there, and your lordship also kindly see the witness says where from this witness get, where he stayed.
That is a
No
question of
particulars,
evidence.
nothing.
That is a question of evidence.
What is
We
evidence?
could go into
What is evidence?
the
You have to
of evidence.
you have to prove your case by document.
Very well. You proceed.
Milord, now the question is, and this picks up, Milord. Section 4 and section 7 notice has got that Stetla address, Stetla station here at Kolkata 27. And that we have given it the postal envelope which picks up the same address, and it came back. That is also there, insufficient, and then the processor served on the notice. So in my submission, that violation of natural justice has not happened. Adequate notice has been given. That I could say, Milord, and the affidavit speaks of that we have sent it. A government officer is speaking of that we have sent it, but we have lost it. So this is what the other thing, Milord, everything has come. We followed the process. We could not take up. We filed application for police help, and it was allowed by the state officer. Thereafter, we could take the possession. So all these due processes are being followed up.
Very well. Anything else?
Milord, this is what.
Yes, Mr. Chatterjee.
He has delayed the process of a report. I need not say about anything about the process of a report before your lordship, especially before your lordship. When your lordship is well aware in a process server's report, the process server must be specifically said where he has gone, where he has served, when he has served, which address he has served, nothing details. And the witness must specify his name and address. Where may I put this question to myself? This Gopal Boirab, where from? Who is he? I don't know.
Very well, Mr. Chatterjee. I have heard. I'll just fix it one day. Maybe I'll have some clarifications. If I have time, I'll dictate it that day only, or I'll reserve and pass it.
Much.
Your lordship can reserve it?
No, because if I have clarifications, I'll go through my report once again, and if I have clarified that, because vacations will intervene in the meantime.
Then your lordship will put it after the vacation.
Yes.
Naturally, your lordship will get required some time.
I'll go through it. If I find that there is some clarification required, I'll ask. If not, then I'll either dictate or reserve whatever.
Because one thing your lordship kindly appreciate that the address which they have sent correctly. I received it. I accepted.
Yes, I have it. I'll keep the records. I have paid that amount. Because today, if I start, it will be hasty. At 12:30, I have original site.
Yes,
it won't be proper.
That I
holding up. Heard Mr. Chatterjee, learned senior advocate.
This duty is-
You get it assigned.
Then again, I have to.
Hard in part, Mr. Chatterjee, it's difficult.
I shall be in a grade two.
No,
Again,
no,
I have
you
to
won't.
mention before the another honorable judge.
Won't be a problem.
Not 470, I'm appealing for the.
This is that matter relating to
Yes,
public
that-
premises.
Siwari has already concluded his.
Yes,
opening.
I was making my submission, my lord. But one aspect has now been cleared because section 11 application was disposed of day before yesterday.
Cleared.
Yes, ma'am.
What has happened
The
there?
issue has been left open. The learned judge has said that both acts will operate in different fields. Whatever claims they have, if it is not covered by Public Premises Act, they will go in for arbitration. And if any claim is raised, which according to us is covered by arbitration, we will have the liberty always to raise the jurisdictional issue. So, my lord, the proceedings are not without jurisdiction, which has been commenced by the show cause notice. That has been.
You
made.
have the order of the section.
Yeah,
11?
we have got the order. We are, it has not yet come.
Not yet.
Not yet come, actually. The order has not been uploaded. This is the more or less view. So, my lord, probably after seeing the
And
order.
then we'll have some clarity
Yes.
on this.
And now now I will require to deal with only the other argument, whether the
yes.
proceeding is dictated.
Yes, the without jurisdiction aspect no longer may be.
Maybe germane.
Yes.
Maybe germane, because it is going in two different fields.
Once the court has held, this court has held that it has jurisdiction, then it has jurisdiction.
Yes.
I cannot
Yes.
override that.
Yes. It is, and it has said that both acts will proceed in their different spheres. There is no conflict. The only it will depend on the claims. If he makes a claim anything relating to termination, I can raise that as a jurisdictional issue before the arbitrator. So the proceedings will go. Both the proceedings will go.
Very well. Then on the other point,
So, my lord,
we'll have that section 11 order once.
yes,
Once
definitely,
it comes, because that requires it is
Yes.
required to be noticed.
So I will now make my submission on the two aspects.
Before my learned senior said, I just want to say one thing, my lord. In the section 11 order, it has not been clarified that the 62 Act will have an overriding effect.
I am also not saying
No, he's
override.
not saying that.
I'm not saying it.
Mr. Sen is also not saying that. Mr. Sen says that the section 11 order has clarified that the two acts operate in different fields.
They have,
What is covered by one field
they have
and
been
not covered by the
negotiated
other
much
field
before the arbitration.
may be taken by the adjudicating authority of the respective fields.
Yes.
That is what is submission.
Yes.
What
So,
is
my lord-
covered by the arbitration, and Conciliation Act will be taken care of by the arbitrator.
Yes.
What is beyond his jurisdiction will be taken
My
care of.
understanding of the order is, my lord, each and every point can be raised before the arbitrator, and the arbitrator will be deciding.
Let us see, let the order come.
But that then the effect would have been that the proceedings under the PP Act, Public Premises Act cannot be continued. That it has been specifically clarified that both proceedings will go on. If any issue is raised, which I feel is within public premises, I will have the liberty there to say. So therefore, this proceeding will carry on. So, my lord, I will now therefore urge only 2 points. Number one, whether this is a proceeding, any sort of bias, institutional bias will vitiate these proceedings, enabling writ court to exercise jurisdiction. And number two, my lord, at the show cause notice stage, the courts generally will not interfere. These are the two
That's
aspects.
settled.
Yes. So, my lord, I'll just show your lordship their averment in the writ petition relating to these aspects, so that I can deal with that directly. Kindly take, my lord, paragraph 27, 28. Another point, of course, is whether the Section 9 court's order is a bar in continuation of these proceedings. That is also what has been argued, that he is acting in violation of an order. That is also, my lord, something which I will urge, my lord. Lordship takes paragraph 27 at page 23.
23.
Yes, page 23, para 27.
Yes.
Kindly see whether it is connection, it is pertinent to mention the arbitration clause stipulated in clause 28 is a standalone clause. It is enforceable in law in view of the law declared by the Supreme Court, view of the Arbitration Act. Your petitioner filed an application under section 9 before the commercial court, praying for interim relief during pendency of such application. Petitioner received an order number 1 dated 22nd July 2025 passed by the SDM Baharampur Sodor, being the collector under section 21B of the West Bengal Public Land Eviction Act 1962. From the order passed by SDO, it would be evident that this is the important part. It would be evident that additional executive officer Murshidabad Jila Parishad placed a proposal before the district magistrate to take necessary action for eviction of unauthorized occupant Asia Healthcare Development from the premises of Rabindranath Thakur Diagnostic Medical Care Center by invoking provisions of this act. As per order dated 22nd July 2025, it will be further evident that the matter was duly forwarded by district magistrate to the respondent number 5 for drawing necessary proceedings. This is the line. As per dictation of DM, proceeding had been drawn up, treated the petitioner as unauthorized occupant, initiated proceeding under provisions of the Act. Petitioner was directed to show cause not later than such and such, and the petitioner was directed to appear to substantiate its claim. This is the background. Paragraph 28 says, respondent number 5 illegally assumed jurisdiction, acted illegally on the dictation of respondent number 4. From the records, it would be evident respondent number 4 is in fact controlling Murshidabad Jila Parishad, more so is the named arbitrator as well lease agreement. Several meetings, respondent number 4 in fact administering Murshidabad Jila Parishad in fact issued necessary to chief medical officer to not to renew license. Dictation of respondent number 4, respondent number 6 did not renew license, respondent number 5 acted as per dictation and issued the order instead of issuing show cause notice. Now, my lord, if your lordship sees the scheme of the act, kindly see, my lord.
Yeah, I have.
Yes. Yes. My lord, kindly come to the act once.
Yes.
So, my lord, firstly, it is a special act from public premises. Now, kindly see public. What is the definition of the public land? Land belonging to or taken on lease by state government, local authority. A government company, corporation owned or controlled by the central government or the state government, and includes land requisition by on behalf of the state government, does not include a government road or highway within the meaning of Highways Act. An owner, kindly see subsection 4, to subsection 4 owner, in relation to any land belonging to or taken on lease by or requisition by or behalf of the state government, that government, in relation to any land belonging to or taken on lease by a local authority, company or corporation, such local authority, company or corporation as the case may be. So, Lord, having regard to the scheme of this act, it has to concern a government land. And, well, Lord, in this case, the land is owned by Murshidabad Jila Parishad, which is a local authority under the act. District magistrate, apart from being the executive administrative head of the district, is also the chief executive officer of the Murshidabad Jila Parishad. So
that was shown.
So insofar as the particular land is concerned, one, there is no doubt it is covered by this act. Incidentally, by virtue of the position, district magistrate is the executive officer of the Murshidabad Jila Parishad, which is the owner of the public land under question. So, my lord, if I am the owner, if I have to take steps for eviction, owner has to take steps for eviction of an occupant, it has to emanate or originate from the chief executive officer of the owner. So, therefore, now kindly see paragraph section 3. Section 3 says, if in receipt of any public land,
collector is of the opinion upon application made by an officer of the owner of public land authorized in this behalf by such owner. That is the first part. Or upon information received otherwise. So there are two circumstances under which collector can assume jurisdiction under section 3. He receives an application proposal from the officer of the owner of the public land, or he acts suo moto upon information received otherwise. Both cases, collector assumes jurisdiction. That's what is the information? Public land is in unauthorized occupation of any person or persons. The collector, then what he can do? He shall issue a notice in such form and containing such purchase to show cause before such date. So what is here? What has happened? Show cause notice has been issued. Now the collector has issued show cause notice on the basis of information received from the district magistrate or his subordinates. That is well within the section 3. Now, my lord, your lordship will kindly see that show cause notice, whether he has acted within the scope of this section. Kindly see, my lord, the notice.
Mr. Sen, 12:30 onwards, I have original file.
Very well.
So
I
then,
suggest.
because in any case you will not be.
I will not finish, but I will get the benefit of the order also in the meantime to show you.
And if I can call a few more appellate side matters.
Yes. Yes. But only thing, my lord, I was praying next Thursday, probably before vacation is the last Thursday.
Yes.
Can
We'll
it-
have it after vacation.
No, my lord, can it be at the top, my lord, so that we can complete it? I will not take much time because your lordship will have the benefit of the order of the section 11.
It should be on the top only because I don't think you have much matters. All the other matters have been dealt with. Whatever was there. So it will naturally move up.
In its position.
Yes. কল করুন অ্যাপেলেট সাইটে একটু কল করে
আইটেম
হ্যাঁ কিছুটা কল করে দিন যদি কেউ থাকে হয়ে যাবে না চলুন নট টুডে যদি কেউ দেয় এই জন্য বলছি কল করে যান কল করে যান your other side
71.
what is the matter your other side is there 485 টাকা কল করে দিন there is a demolition order let me take that first
The private respondent.
you please wait there is 485 there is a demolition order he had mentioned it on urgency grounds
My understanding is on behalf of the state.
Thank you 485 take
In this matter, I am for the petition. I am challenging a notice issued by the assistant engineer with regard to the this demolition work or we carried out on 12th of December. That
engineer.
Assistant engineer. That is the matter my case. Page 69 is the review notice.
My lord, may please come to the order passed by Justice Honore.
No, may I just take the thought brief of this case, what is happening in this matter? Page 69, my lord.
Page 60 is the first order.
Page 69.
Yes, 69 is the order.
Yes.
This is the impugned notice we have been challenged in the instant writ petition. May I just take what is the happened in the brief thought fact of this case?
Yes.
This private respondent, here, he filed a writ petition alleging the encroachment, alleging the blockage of his ingress and egress by the club. That is the petitioner before your law.
The private respondent.
Private respondent, we have sent the notice on immediately. We pray for dispensation of Rule 26 also in this writ petition.
Yes. Just a minute. Let him hear.
He filed a writ petition before this honorable court alleging that blockage of his ingress and egress by the club. This is in his writ petition. This court has directed to initiate a proceeding. First, demarcated the property. Thereafter, 10-1 notice of 10-1 proceeding was initiated, and thereafter, the 10-3. That was the direction. The assistant engineer, the block land and landing officer, conducted an inquiry, but the copy of the report is not served upon us. That is our case. First time, the assistant engineer, the issues a notice at 10-1, and thereafter he sent the matter 10-3 before the subdivision officer. Subdivision officer conducted the hearing and passed an order in my favor. No matter why, your lordship can. Yes, no, that is at page 63. The last order, the order is dated 2nd of May 2025.
Yes.
Page 64. The order number 4.
Yes.
The case records are put up today for hearing. Mr. Bindaman Mondal, this is the private has appeared along with the learned advocates. Mr. Ranjan Mondal and others are present, representative of Assistant Engineer PWD Bagnan, DLRO Bagda and the Pradhan Bagda Gram Panchayat are also appeared, heard all of them. Here is the copy of the order of the Honorable Court as passed in WP number such and such. The order of the Assistant Engineer passed on 25th of November 2024. The inquiry report of the BLRO Bagda and held on 23rd of October 2024. It appears from the order of the Honorable Court as passed in WP number 21771 of 2024 on 24th of September 2000 that the petitioner has submitted a representation dated August 14, 2024, annexed P4 at page 25 of the writ petition, but this same has not yet been disposed of. In view of above, the respondent number 5 is directed upon serving a prior hearing notice at least of 7 days to the petitioner and private respondent number 7 to 9 shall cause a physical inspection on the alleged illegal structure and encroachment on the PW land, and then after granting them an opportunity of hearing shall dispose of the representation dated August 14, 2024, annexed P4 at page 25 of the writ petition by passing a written order in accordance with law. It made clear that this has not been gone into the rival contention of the petition of the private respondent. They shall be free to. What has happened? Ultimately, there is no independent finding. Kindly come to the page 67.
Yes.
I have carefully examined all the issues stated above and came to the conclusion that there is a 7 feet open passage of movement of vehicle from PWD Road to house of Sri Bindaman Mondal. Moreover, there is another 12 wide back top road of the Bagda Panchayat at the western side of the house of the petitioner. The question regarding the problem of ingress and egress of the petitioner from their house does not arise at all. The claimed portion of the boundary wall as written in the deposition of the petitioner has been demolished. Now they can run their groceries without any obstacle. The problem of the livelihood is duly removed. If the remaining portion of the boundary wall is removed, now the problem will arise at the time of Kali Puja and Durga Puja and other religious festival between the petitioner and the private respondent, which may lead to the breach of peace. The private respondent.
This order is in favor of the person against whom there was an allegation.
My lord, please come to first page number.
No, my lord,
This
no,
is the
I am
order
not
of
completed.
Honorable Justice Arulupra.
Yes.
Right. My lord, please come.
My lord, these order, my lord, kindly see that, my lord, there is no, my lord, kindly
There is an
appreciate.
order,
There
there is
is,
a contempt of authority.
my lord, there is.
Let me hear him once. I have heard you. Yes.
My lord, there is an order dated 24/9/2024, page 60. This is WPA 21779 of 2024.
Yes.
In that said writ petition, the petitioner hearing is also a response and also made represented by a lawyer and appeared in the matter. My lord, please come to that order, the operative part.
Page
60, my lord. 60.
60 is the first page. Operative page is there.
62.
62.
Yes.
Within the confirms the illegal and unauthorized structure and encroachment as alleged, the respondent number 5 and other appropriate state authority shall take all necessary steps, all necessary and consequential steps to give an immediate effect to the said reasoned order, but positively within period of 4 weeks from the date of the said reasoned order to be passed in accordance with law. It is made clear that this order shall not create any right or equity in favor either of the petitioner or in the private respondent if they do not succeed in the respective contentions before the respondent number 5 and strictly in accordance with law. Since no affidavits are called for, this is the order. After that, everything has taken place. Then please come to a contempt petition has also been.
No, matlab the SDO order, matlab the petitioner, but here the respondent, they are not challenged. Matlab with my reading, there is no independent finding with regard to matlab the encroachment of the government land or not. The subdivision officer.
Where is that finding?
Kindly see the finding.
Page number 71 is the contempt order. Page number 71. Why it is a clear instruction, my lord, from this honorable court. A rule has also been issued. That a complete demolition has not been
No,
taken
there is no such direction in this order.
Disputed area has been encircled with fencing within bracket Calcutta, and containers have taken possession of the subject land, but no further steps have been taken.
The contempt is pending.
Yes, and
That is pending, and you are required to file a report.
No, that's because we have to complete it within 12 months.
No.
We have to complete it, my lord.
Rule is made returnable on 9th of January.
Yes, my lord. But this order has to be completed within 12. That is why he also submitted. And this is the police report, my lord.
My contempt.
What is the notice that you are challenging?
That is page 69.
But he,
Page
my instruction
69.
is present in the side meeting.
Page 69, my lord.
And whose complaint it was? Private respondent.
Bindavan Mondal. Page 69, kindly come to the improvement.
Private respondent was also required to demolish something.
Yes.
That they have done. Nobody has done.
Some portion has been still Katasar, which my lord has that
My lord, kindly
completed within 12.
My lord, we kindly come to the page 67 operative part of the order of the 10
Please agree by the order of the Honorable Justice Aniruddha Ray, then you can present.
No, there is no agreement. My lord, kindly come to page 10.3, my order, page 67.
Fall out with that order.
My lord, the claim portion of the boundary wall as written in the deposition of the petitioner has been demolished. Now they can run their process without an obstacle, and the problem of the livelihood is duly been removed. If the remaining portion of the boundary is removed, now the problem will arise at the time of Kali Puja and Durga Puja and other religious festival between the petitioner and the private respondent, may lead to the breach of peace. The disputed boundary has already been demolished.
Now we will abide by the order of the Honorable Court.
No, if this order does not require you to demolish, Honorable Court did not say that you will have to demolish whatever is there. The Honorable Court said that in the reasoned order it is found that there is something which is required to be demolished, then you will demolish.
Yes.
Where is it? It says that has already been demolished.
No,
where is that?
Yes, my lord. That part which is encircled, my lord, please see the order of the that Katatar.
Which
that,
Katatar? Which page?
Page number 72, my lord.
Page 72. 72.
Mr. Royal Banerjee, learned advocate appearing for the contemnants, filed a report dated November 18, 2025. put under the signature of the alleged contempt number 1, showing that the disputed area has been encircled with a fencing within bracket kata tar.
Yes. This is the observation.
Yes.
The report, my lord, kindly sir.
You were present, why did you not bring it?
No, my lord, in the contempt proceeding, I was not present. In the contempt is between the petitioner and the, my lord.
So you should take out an application there. How can a report suddenly
No,
intervene?
no, my lord, kindly come to.
You take out an application for clarification there.
No, my lord, with regard to in contempt proceeding, I am not the party in the contempt petition.
That I understand.
My lord, kindly come to page 69, my lord, once.
You can go on shouting without hearing.
My lord.
No purpose. No, my lord. You should have approached the honorable court by way of an appropriate application. Why this press writ petition here? This is you cannot pitch one court against the other.
No, my lord, in the similar circumstances, this coordinated of this one honorable court passed an order. Well, kindly see this order, my lord. This is unreported. My lord. My lord, kindly come to internal page 2. Paragraph number 4, my lord.
No, sir. This is not going to help you because you come to page 67.
My lord.
Paragraph 3.
My lord.
If the remaining portion of the boundary wall is removed, this does not show that the boundary wall is not illegal. He was not required to comment on what will happen if it is removed or not. If it is illegal, it has to be removed.
But there is no independent finding in the order of the temporary
Not
authority.
required. This itself is an independent finding. If it is removed, then this will happen. Therefore, this should not be removed. Is not.
But my lord, the order of the SDO, my lord, the kindly one thing, my lord, may I just, my lord, page 69. I have a challenging this notice on the two grounds. First, my lord, the assistant engineer under, my lord, under the West Bengal Highway Act is not an authority to issue any order of demolition. But he has an authority to issue a notice under removal. The removal, he has to be, the demolition has to be carried out by the subdivision officer. So, my lord, the assistant engineer, my lord, under the law of the West Bengal Highway Act, my lord, show me the law. My lord, kindly show me the law.
This letter refers to another letter dated 1st of December 2025.
No,
that is the letter issued by the SDO, and on the basis of that letter, this letter has been written.
Well, we have been served with that letter, only that
You
letter.
have asked for it. This cannot be a ground to challenge in the repetition.
With due respect, kindly appreciate the order.
December letter, can you produce tomorrow? The letter which has been issued by the STM, because it refers to a letter that appears to be the order of demolition. You have to have challenged that.
We have been challenged, even we have been challenged appeal. We have a right to paper an appeal. We paper an appeal. Yesterday, on 10-4 authority, before the 10-4 authority, before the district magistrate. The appeal is still pending. We paper an appeal. More to you will kindly take travel to the order of the contempt court. Whether the contempt court is directed to demolish him. Only to take the safe from the contempt court. He issued the notice of the demolition. You will also kindly take travel to the order impugned. The court has says that if there is a reason order, consequential step will be passed. Kindly see the order, parent order. That is at page.
You bring that 1st December letter tomorrow. I'm fixing it tomorrow. And in the meantime, you serve the private respondent.
We are already served.
Already served will not do. They have to be here. Third, learned advocate appearing for the petitioner and the learned advocate. ও 475 এর ভেতরে ঢুকলো কি ইনকাম ট্যাক্স লেখা আছে আর এই 485 টাও এর ভেতরে ঢুকলো কি করে ল্যান্ড ম্যাটার ছিল আপনি সব এক জায়গায় দিয়ে দিচ্ছেন ল্যান্ড ম্যাটারই তো এটা তো ল্যান্ড ম্যাটার নয় এটা আনঅথরাইজড অকুপেন্ট ফ্যাক্টর ম্যাটারের হেডিং এ আপনি দিয়েছেন ল্যান্ড ম্যাটার তো আমাদের জুরিসডিকশন নেই যেহেতু এসছে নতুন বলে সব একসঙ্গে ঢুকিয়ে দিচ্ছেন অসুবিধা হচ্ছে তো Yes, original site to call.
My lord, may I be permitted to mention a matter in the original site?
No, not now.
My lord, item number 63 in today's please, my honor.
Yes.
It's under the heading hearing, my lord. The difficulty is that the petitioner was released from her service and her VRS has been withheld. Arbitrarily, her VRS has been withheld and she is suffering from illness. It's more than 1.5 years, my lord, she is being going through the pain.
Next week, I shall arrange for some hearing matters to be taken up.
Kindly.
There in the list, I'll take up some.
Deeply appreciate.
I am seeking my lord's very kind leave to actually mention two very short hearing matters. These are not in the list, Your Honor, but then the point is very short that while my appeal was pending before the CITA, the department has recovered more than 20%. In fact, in these cases, they have admittedly recovered 100%. The affidavits have been exchanged, Your Honors. There was no scope for an interim order in these matters. These are very short matters. Your Honor had last week passed a similar order in the case of Gaurav Enterprises, Your Honor. It is exactly on those same lines, which is why I am troubling Your Honor. If it may be taken up on Monday, it was Your
It will
Honor.
appear in the list, then mention, we'll upgrade it.
I am extremely grateful.
Any other mentioning to original site? Extension of interim order item number 1.
Malets, and for the petitioner, Malets, this is for the extension of interim orders, Malets, expiring end of December, Malets.
Item number 1, Mr. Dutt is there, he's coming.
He was there just now. Okay. I am extending the interim order. Your affidavit in opposition you have filed? No. You will not file?
No, my lord.
You will not file or?
No, we will file, but right now.
Listen. This matter is appearing under the heading extension of interim order upon being mentioned therefore, FOR, upon being mentioned therefore. Full stop. Paragraph. Heard learned advocates appearing for the respective parties. Full stop. The interim order which is subsisting and is to continue till the end of December 2025 is extended till the end of February 2026 or until further orders, whichever is earlier. Full stop. Mr. Dutt, learned senior standing counsel appearing for the revenue authorities, seeks extension of time to file affidavit in opposition. Full stop. Let such affidavit in opposition be filed within
4 weeks.
4 weeks from date. Affidavit in reply, comma, there too, comma, if any, comma, be filed within. Affidavit in reply within?
It's 2 weeks, Malets.
2 weeks thereafter. Listing it to bolaiye. List this matter in the monthly list of February. List this matter in the monthly list of February 2026. Monthly list of February 2026.
Item number 2 and 3 also, Malets, similar praise, Malets.
Same thing.
Same thing.
2 and 3 same thing.
Only
same order.
May I say only one thing? These were belonging to my Lord Justice Dasdi. So, he was very meticulous in filing the opposition.
He has filed.
Perhaps he has been filed. I have not been given a copy.
affidavit 2 নম্বর আর 3 নম্বর
একে what? একে বোঝায়।
কি এফিডেভিট আছে না 2 3 আছে 3 নট
Then
Deeply obliged.
তাহলে 3 ওই অর্ডারটা হবে না item 3 you have filed your reply
Item 3, item 3 I have not filed my reply, my lords. I need some time, my lords.
item 2 এ এফিডেভিট নেই তো 3 এ 3 এ লিখে দিন 3 এ একটা লিখে নিন শুধু Mr. Goel, learned advocate appearing for the petitioner, seeks extension of time to file affidavit in reply to the affidavit in opposition filed on behalf of the respondents. Full stop. Let such affidavit in reply be filed within 2 weeks from date or listing a same February month.
Obliged, my lords, deeply obliged.
আর ওই এক্সটেনশনটা থাকবে এক্সটেনশন অফ ইন্টারিম অর্ডার থাকবে অ্যাফিডেভিট ইন অপোজিশনের পার্টটা চেঞ্জ হয়ে গেছে ঠিক আছে যেহেতু এখানে অপোজিশন ফাইলড হয়েছে ওইগুলোতে অপোজিশন ছিল না এখানে শুধু রিপ্লাইয়ের ডিরেকশনটা আর বাকি উপরের ওই এক্সটেনশন appearing under the heading extension of interim order তারপরে continue which was continuing till December 2025 is extended till February 2026 ওই সব থাকবে till the end of February 2025 মাঝখান হ্যাঁ আর ওখানে অ্যাফিডেভিট ইন অপোজিশন ছিল এখানে রিপ্লাই মানে অপোজিশন রিপ্লাই দুটোই ছিল এখানে শুধু রিপ্লাই দুটোই বলতে করছি জানে নাকি যাই হোক
I am for the respondent.
Yes.
Respondent. Union of.
My lord, I am for the respondent.
Mr. Nag, he's with you or he's
My lord, I am appearing for the port trust.
He is appearing for me, with me maybe. You know, put it on that. Yes.
My lord, this matter was marked to me, my lord. There might have been, my lord, I am not aware because
No.
it was marked to me
My
as
advocate on record was assigned with the matter that is I am appearing.
There is another set of advocates appearing that is between you and Mr. Nag now.
Well, that will, my lord, if that is there, Mr. Nag is my senior, my lord, he can obviously appear, my lord.
Very well. Yes, sir. What is your matter? Tell me.
This is a supplementary affidavit.
Supplementary affidavit. Why?
I have not received any copy of supplement. Supplementary.
We have already served the copy.
My lord, it was served to me, my lord, and the department had called me, my lord, that is the confusion. My lord, Mr. Nag is appearing in another writ petition. My lord, similar parties, my lord, he is appearing in the other writ petition. I think that is at the appellate side.
Why is there any order to file supplementary affidavit?
No, my lord, no order, my lord.
No as such order, but
No,
we had,
this is first time appearing before your lordship.
Then why
It
supplementary
appeared
affidavit? Why? What is
because we had in the main petition, we had given the prayers in a similar case. So I thought of giving a supplementary affidavit with all the documents.
Keep your supplementary now. We will not take that. First, place your case and let us see if supplementary is at all required.
Okay. So I'd like to draw your attention to page number 11 of the Public Premises Act.
Which section?
Section 4. Notice
Yes,
to
Yes, before taking it
My-
to law, first place the fact.
Yeah. Sir, this petition has been filed because your petitioner have been wrongfully illegally been evicted from his factory premises without notice for personal hearing, without any eviction notice in the form of Form A, without any inventory as per the statutory rules. Again, the respondents have forcibly taken the possession of the assets and subsequent steps for the sale of the assets of the petitioner without any notice in the form of Form C. No notice was given to us. The notice was given to a company which got duly closed by the Union Cabinet Ministry's order.
And you were the recorded tenant.
We were the subtenant. I'll come, sir. And
Notice was
which,
given to your tenant under whom you were the
sir,
subtenant.
the tenant satisfied the order. The tenant is Burn Standard Company Limited. So through a resolution plan filed in NCLT court, the decree was satisfied. So they have basically again re-executed the same satisfied decree. Interestingly, even after accepting rent, they are accepting rent from us with communication, with an email.
Show me the documents.
Yeah.
Well, before Lordship goes into the factual issue, well, today basically what I gathered, he is seeking an order of release of goods, which he claims to be the owner. Now, well, that is covered.
Not just claim. The respondents have recorded.
Well, that is covered by the division bench order. Well, I am not taking my case. Well, Lordship takes two orders. I think Lordship will get clarity about the matter. Well, here, first, well, Section 5 eviction order was passed. That was challenged up to Supreme Court. Lost. Thereafter, pursuant to the order of the estate officer, we took possession of the property. Now, a challenging position, a writ petition was filed before the single judge. Single judge did not incline to pass any order. But from that, an appeal was filed. In the appeal, in the supplementary affidavit, they prayed the same prayer which is praying here for release of the goods. Now, the division bench has conclusively negated such order. Against that, went to Supreme Court, and before Supreme Court, it was lost. Now, I think this is now covered under the division bench judgment. Two orders I am placing, and then he can go into the matter. Kindly come to page 288 first, that is the order passed by Justice Sean Group.
288.
288, my lord.
288.
The petitioner seeks restoration of possession over the relevant premises. It is undisputed that an eviction order has been passed at the instance of respondent number 2, the owner of such and such. The petitioner claiming to be subleasing that which are disputing, one standard company participated in the said eviction proceeding. Subsequently, petitioner filed an appeal against the eviction order, which was dismissed. It also appears in execution decree by the possession of the relevant premises was handed back to the respondent one with the assistance of police. In the light of foregoing, I am not inclined to restore possession to the petitioner by way of interim order. The matter shall be decided finally upon exchange of affidavit by the parties. Now, this is the order. Challenging that, he went to division bench also by way of a supplementary affidavit. He made the prayer for getting back the goods. That is at page 292. Your Lordship kindly takes. Lordship, paragraph 2 onwards I am placing. By the impugned order, the learned single judge refused to grant interim protection to the appellant. Appellant claims to be a tenant in respect of an immovable property. Appellant claims an appellant was tendering rent month by month to the authorities were accepted. The appellant was evicted, seeks restoration of possession. The learned advocate appearing for the respondent number 2 draws attention of the court to the fact appellant was evicted. Proceedings under such and such was initiated in respect of the property concerned. Decision of the is assigned right up to Honorable Supreme Court without success. Learned advocate appearing for the respondent number 2 draws the attention of the court to the relief sought for in the writ petition. He submits that interim relief sought for in the nature of final relief and that in facts of circumstances should not be granted. Union of India and state are represented. Writ petition for the appellant is still pending. Appellant was a subleasee. Appellant claims his movable properties were sold at that and that he was disposed. Sought restoration of possession as interim. Single judge refused to grant such. Now, very important, two paragraphs. A proceeding under Act of 1971 was initiated in respect of property. In respect of the property, appellant is a leasee at best. The decision of estate directing the eviction order upheld right up to Honorable Supreme Court.
lessee is not before the writ court. Appellant claims the title through the lessee who lost the title. Movable properties, very important, found in the proceeding under 1971 are required to be sold by auction. We see no informity in such action of the respondent number 2 and the appellant to be put on position as interim measure. So, it is very clear because they, by way of a supplementary affidavit, did that. Now SLP, it was challenged before Supreme Court. Page 296 lordship takes. Now, we are not inclined to interfere with the impugned judgment order passed by the High Court. Hence, the special leave petition. Kindly have a look at the supplementary affidavit they have filed, supplementary affidavit, which is not annexed, unfortunately. Just their copy I am placing. Kindly have a look. I only have one copy. Kindly, pardon me for that. Kindly have a look at 2 paragraphs on the basis of which he invited 4, 5, and 6. I have folded the. Oh, I'm going to copy it. Oh, I'm sorry. I'm sorry. Now let's see paragraph 4. Now he is participated in the section 6 proceeding. As per detailed auction catalog, Lordship got it, paragraph 4, Mallam?
Yes.
Paragraph 4. Mallam, this is a records of the appeal court. Mallam. As per the detailed auction of such and such, the respondent auctioned approximately such and such piece of such and such. It is pertinent to mention, herein the number of materials auctioned are lesser than the actual stock, being such and such raw materials when the respondent took forcible possession. A theft has been taken place. That is also the case here. No action taken. Now, done. 6 is important. That till final disposal of the matter pending before the Honorable High Court at Calcutta, respondent must abstain from auctioning the petitioners lying in the aforesaid. They invited it and got an order from the division bench refusal of this order. So, today, possession.
My lord, it was specifically written to Calcutta Port Trust when they published an auction notice in the name of Burn Standard that the material belongs to us. We never participated. I can show you the documents first. Number 2, in the divisional bench, my friend Mr. Nag, he was there. There was no submission from our end. Our senior lawyer who wrote the petition, who appeared in the single bench, who was supposed to appear in the divisional bench, he was absent without any prior notice. So there was no submission at all. He knows it well. So whatever the learned divisional bench understood, learned judge Mr. Basak, Honorable Judge Mr. Basak, he ordered. Again, your lordship, the act specifically says, the rule specifically says inventory should be taken before eviction. That was not done. The act specifically says the person evicted, he should be given the notice. We were the person who were evicted. They had filed a caveat in the lower court. I have a copy of caveat. They have specifically recorded that we were evicted, but the notice was in the name of the Burn Standard.
You are bound by that notice. You are
How bound, sir? We are not. No.
He is not the recorded tenant.
Then why are you mailing us for? Sir,
This is not.
I cannot.
The court maintain some decorum. Once you claim subtenancy under a person who is the tenant and who is your landlord, in that sense, any order against the landlord will be binding on you. You don't have an independent title. You are claiming through a person whose title has been taken away. You have no title. That's as simple as that.
Sir, Shyama Prasad Mukherjee Pur, they emailed us for payment. It's there in the document, in the petition.
Rent was taken without prejudice to our rights and convention. That we do in every cases, Malad. Now, Malad,
they had specifically emailed, please use other mode of payment.
What is written there?
So I'd like to draw your attention to page number 292.
292.
Yeah.
292. 292 is the order.
Sorry, 202.
202. 202. Yes, 202.
Yes. So see,
This is a caveat.
this is a caveat. They have filed upon a company, Burn Standard Company Limited, which is non-existent.
Very well, that is
Yeah, number one.
you show
Number
me
two,
what-
AMBE boards, me. So they have specifically mentioned, recorded that we were the occupant. The act specifically says the person evicted, he should be given a notice in regard to any auction. The apex court has specifically said in regard to any public auction, there should be 100% transparency.
That is already a subject matter of challenge in the other writ petition which is pending.
This
Cannot be
we,
here.
we are basically, sir,
The scope of this writ petition is only release of goods. Only that much.
no, the cancellation of the auction too.
There
The,
is
this auction is completely illegal.
And why did you not take this point in the other writ petition that is?
Sir, there is no prayer in regard to the material.
Why did that?
Sir, that time auction didn't happen. This is why whatever the learned divisional bench understood, since there was no submission from our end, the learned divisional bench ordered the same. There is no prayer in the writ in regard to the material.
So why didn't you approach the honorable division bench?
Sir, I was sent to the Supreme Court by my lawyer. This is why we have been continuously misguided again and again. This is why
This should not be done. Mr. Shen was appearing Shakoshin.
he
On
didn't.
that
You
day,
know,
he
you
was
know well.
his junior appeared representative.
She is 3 months old advocate.
All the
And
submissions, please don't make in court now. What is your Mr. Nag? When was the auction held?
Malad, auction, Malad, kindly take Malad 1 minute. Malad, page 206 onwards, auction is completed. Malad, he appeared before the estate officer. 206 onwards, Lordship sees. It's a section 6 proceeding was duly initiated. I will tell you, Lordship, Malad, where he appeared before the estate officer in respect of. এই কোন অর্ডারে দেখো তো অ্যাপিয়ার করেছে সেটা মানে লর্ডশিপ will find 210 the auction notice was published on 14th March 2025. We are in December. What is the scope of interim order? Lordship says 210 is the auction notice published. Then Malad, I will tell you, Lordship, Malad, where he appeared.
And when did auction actually take place?
Auction কখন হয়েছিল? Man, few months back, Malad. Few months back, auction, Malad. Few months back, auction took place, Malad. 210 is the auction notice. Section 60.
Page 225, Annexure P33 is the order in which he appeared.
Yes, I'm thankful. Well, I think my learned friend is representing Union of India. Also, I'm thankful. Union of India to represent Kochi. Well, Lordship, I am thankful to my junior minor 225. Lordship, please. I am thankful to him. Well, I was. Well, Lordship, please 225. In terms of forum's earlier order, has your Lordship got that 225?
Yes.
In terms of forum's earlier order, the authorized officer personally and sought for some time to file inventory report, prayer for time is hereby allowed. SMPK is one again directed to such and such. Department has placed on the department was placed before me an application of NB board, that is him, with respect of theft of some iron material, hereby directed to confirm the veracity of such fact of theft and MB boards in writing along with inventory report before the next date of hearing. It was considered by the estate officer. And thereafter, the property.
There is no scope, Mr. Agarwal, to pass an interim order. I have to invite an affidavit because today only I cannot direct release of goods. Let their affidavits come after the.
Sir, I am not challenging. I'm challenging this auction. This auction has been done.
That also has to be decided on affidavit. I cannot immediately decide that without calling for their written objection to the writ petition. That has to be there on record.
I'm grateful, ma'am.
Sir, I would request you pass an order so that the delivery of the material doesn't happen till then.
I don't even know whether it has been done or not.
Nobody knows.
Of March.
This auction is completely illegal. They have not done any inventory. They have not done any valuation. No forms he was given to the owner of the goods.
Your writ petition is of November 2025.
Correct.
Auction notice is of March 2025.
Sir, I'm appearing in person. I've been completely misguided all these days.
Appearing in
Sir,
person.
I am not asking you to pass any order.
I cannot get in.
Sir,
I will have to go by the rules. They are entitled to file an affidavit in opposition. Let them file.
sir, till then they cannot deliver the material. Just pass this order.
Whether it has
Sir, once the sir
what
this
has happened, nobody knows.
sir
What has happened,
sir
nobody
this petition will get infectious if the material is delivered. Then what will be the point?
Then, Mr. Nag, you take instructions, come back when, what is the status of that? Let us see.
My lord, I tell your lordship, my lord, what right he has. Because I tell your lordship, two things are very clear. Possession upheld up to Supreme Court. My lord, the challenge to sell, my lord, already decided against him by the division bench. I showed the supplementary affidavit to your lordship. My lord, it is now covered by the division bench judgment.
Did the divisional bench said conduct this auction illegally?
The petitioner. Now, this writ petition seeks an order directing issuance of a writ of mandamus, commanding the respondent, within inverted comma, to forthwith hand over the goods stroke assets, including the shed, stroke machinery, stroke finished products, page 38, prayer stroke raw materials, prayer rate of procurement. The writ petitioner claims to be a sublessee under one Messrs. Burn Standard Company Limited, against whom, proceedings, eviction proceedings under the public premises within bracket eviction of unauthorized occupants bracket closed act, 1971 had been initiated and concluded by an order of eviction dated.
One minute.
Your Lordship.
Eviction is 29th August 2001.
Your Lordship.
August 29, 2001. Yes.
So let me tell you, Burn Standard Company filed a resolution plan, and as per the sir, just 1 minute. Okay.
You will come up with by way of a reply affidavit once they file the affidavit. I'm not deciding anything. Full stop. It is brought to the notice of the court that the petitioner also participated in the eviction proceedings.
Eviction as well as all proceedings.
It is submitted on behalf of the respondent. Eviction proceedings where, can you show any order here?
Yes, I have eviction order. Well, the lordship is the eviction order. And it's the eviction order. I am finding it from the brief, but I am handing over the eviction order. Well, just a video. Lordship will find that in the end of the case, on
where is his name appearing?
MB board. Lordship will see it's written.
This order is not annexed.
Annexed. Well, it is from page 54. It's from page 54. Lordship, I had got that. Page 56, Lordship. I'm sorry for troubling you, Lordship.
Yes,
Well, at page 56, will find.
it is evident. It is pointed out, Thakur, it is evident that page 56. It is evident from the order dated August 29, 2001 that the petitioners participated in the eviction.
Sir, we didn't.
You have
No, sir.
56.
We had specifically written them that the material belongs to us.
Eviction proceedings
Oh.
and accepted their status. No, unaccepted now. Very good. Participated in the eviction proceedings. Full stop. Paragraph. It appears that there is an order passed by the Honorable Division Bench of this court on July 25, 2025 in an appeal preferred by the petitioner against an order dated 16th May 16, 2025 passed in WPA 5666 of 2025, whereby the Honorable Division Bench found that movable properties found in proceeding under the Act of 1971 are required to be sold by auction, and that there was no infirmity in such action of the respondent number 2. Full stop. Paragraph. In such view of the matter, there is no scope for passing any interim order as at present. Full stop. It is also noticed that the notice of auction, which page? 230.
210.
210. 14 March 2000. Yes, that the notice of auction was published as far back as on March 5, 2025, and the writ petition has been filed only on November 18, 2025. Full stop. In such view of the matter, there is no scope for passing an interim order as at present. Full stop. Paragraph. The issues raised in the writ petition must be decided after exchange of affidavits. Full stop. The respondents shall file their affidavit in opposition to the writ petition within 3 weeks from date. Full stop. The petitioners shall be at liberty to file affidavit in reply, if any, to the affidavit in opposition filed by the respondents within 2 weeks thereafter. After receipt, 2 weeks thereafter, list this writ petition for hearing. Once again, immediately after expiry of the time fixed for exchange of affidavits. So effectively after 5 weeks. Yes. Great. What? Restoration of an interim order which had expired. Mr. Nag, learned advocate appearing for the respondent court authority, hands up the court a supplementary affidavit. And submits that the same was filed by the petitioner. The appeal referred by the petitioner being MAT 806 of 2025.
So the cause is different. The prayer is different.
2025, whereas the petitioner had stressed that till final disposal of the matter pending before this court, the respondent should abstain from auctioning the petitioner's materials lying at the subject premises.
I was wondering, one line can be included. Supreme Court also did not entertain the SLP from the order passed by the division.
Did the apex court ever said do the auction in an illegal way?
The order dated point blank.
Mr. Nag, you know well that no submission happened.
Order dated such and such passed by the Honorable Division Bench was carried in appeal before the Honorable Supreme Court. Full stop. The special lease petition filed by the petitioner against the order of the division bench was however not entertained by the Honorable Supreme Court.
What?
Or on Monday, the urgent state officer, despite one of the interim order restraining him from proceeding.
Let him pay at least 10 lakh. Due is 18 lakh 92,000.
Then we'll hear it. We'll hear it.
Let him.
My friend had made an undertaking that they will not proceed
Where is
against.
the undertaking? Show me the undertaking.
My lord, it was made during mentioning.
And what has been done? In spite of my
It
undertaking,
will
what has
not
been done?
appear on Monday, it will appear on next Thursday, on the day when I take unauthorized occupancy matters. Next Thursday. It will.
Kindly, if you are allowed to take an adjournment, my lord, before the.
Let me pay. You take. I have not stopped you. It's up to you. And I'm not passing any order that should adjourn. You persuade them, the matter is in the list, but it will be taken up on the day when unauthorized occupancy matters are taken. Next Thursday.
Next week. But I'm actually for personal reasons, I'm traveling on Thursday afternoon and I'm not there on Friday. So
Then it will be week before the vacation.
and this is the notification will come in the meantime. So
Mr. Basri, what about that? So can you get in touch with the AC and find out an earlier date?
No, this is not. The flight is at 6 o'clock. Right? So therefore, second half. It will be
So if we
difficult.
can have it in the morning, will it be all right?
Yes, sir.
Thursday morning, if we can have it.
Thursday morning.
We'll have it for 1 hour, the same time with which for which it would have been taken in. I mean on Thursday. I mean today. But then 12 will be okay. 12 will be finishing by 1:30 maybe if it spills over.
Yes.
The recess.
Should be safe, I think. So what my learned friend, he was arguing that second matter, he can complete his submission.
That can be completed.
And
no, his submission.
Because the matter has been going on, this is more been doing
This becomes very difficult. It becomes very difficult after this. Is the SG here? Please ask him to come once. Ask him to come once. So that the court can also have a word with him. Ask him to come so that we can fix an earlier time if possible.
I'm here. My lord, I just want half an hour. Can I finish today?
Mr. Salve, there is a request for adjournment on behalf of the Government of India, Union of India.
But my lord, I can finish. They can continue tomorrow.
That can be done. That can be done.
Yes, we can finish in.
We can hear Mr. Salve. Becomes difficult because
I don't need more than 20 minutes, 25 minutes.
we can hear Mr. Salve. We'll hear you on Thursday in the morning. In the small hours of the morning, we can hear because then Mr. Salve's presence won't be required. He'll be having inconvenience in the morning because of the difference of the time gap.
One of things.
So we can have it early in the morning on Thursday. That will help Mr. Ketan also. And the ASD will also be present by that time. And Mr. Salve can conclude because your submissions and Mr. Salve's submissions will not be to the contrary. You are not contradicting each other. You are in support of each other. So it won't be a problem if I hear him today. Yes, sir.
Wait. My lord, I just want to.
If you can call him, please. Yes. Mr. Salve is appearing in the second matter also, or he's not appearing in the second matter? So, what about Mr. Raju's submissions in the second matter? You are still to make some submissions.
Take 5 minutes, I'll point out the pages, I will advertise some of the pages.
Mr. Salve, there are two matters which are being taken up together. ये तो होना चाहिए ना नहीं.
I don't think there is any difference in the facts.
Yes, so the learned advocate appearing for the petitioner in the second matter, he needs 5 minutes time to wrap up.
Yes.
We should allow him that leverage and then we shall come to it. Yes.
Yes, sir.
Second Padini. Because then the things will be in order. Half of this, half of that.
Krishna Srinivasa.
Yes. Yes.
As stated earlier by Learned Srinivasa, that the issues are identical. I'll just point out the relevant page numbers in where we have made the submission and where they have come up with the new numbers as per the disclosure statement and our correspondence thereafter. I'll just mention the page numbers and I'll end mine. On the last occasion, I had drawn this honorable court's attention to the relevant paragraphs under the final findings which are in dispute. There were only 159 and 160. Two issues were raised, which was stressed on by my in the first petition. The first issue relates to related party transactions which relate to ethane, which is a raw material used in the manufacture of cyanide products. The details of these transactions were at arm's length price. The dispute was whether it is at arm's length price. Our answer was it is at arm's length price. What third party costs, I adopt the same costs. Kindly come to my letter of 6th June 2025 at page 368, volume 3. Millet 368 it starts. And yes, on page 370.
Three 370.
370, yes, sir.
Yes.
Is my response. I have given the purchase register sample invoice for purchase of ethane for each quarter of the period of investigation. The details are redacted, but I have provided this information. Subsequently, on another letter, 14th of July 2025 at page 425,
425, yes.
Yes, sir. Middle paragraph, B, small b, alphabet B.
Yes.
We have relied on a trade notice issued by the government and stated that our related party transactions are at arm's length price and comparable arm's length price is adopted. And I have given the details thereafter. Thereafter again on 17th of July 2025, appearing on page 429.
Yes.
On page 429, the letter starts. On relevant page is 430. The next page,
430 you had pointed out.
Yes, sir.
Last occasion.
Yes.
B, response.
Yes. And 431.
431, response.
Yes, sir. This is my response that I have adopted. Now, we have also relied on, which was stressed on in the earlier petition also, a chemical market analysis report and based our prices on that. This is on with related to the first issue. With regard to cost allocation, as to what are the various costs.
These are all on merit.
These are all on merit.
Your point will be that your we will have to demonstrate that essential facts are not communicated to you.
Yes.
What is that?
Yes, Milad, all of these are essential facts as stressed in the earlier petition. Why is because Milad, this entire investigation, one of the facets was which started this entire investigation by the DPPR was whether do I follow arm's length pricing in my related party transaction for purchase of ethane. One of the issues is, and Milad, I am showing all these relevant pages is because Milad, this adds to my cost of production. The cost of production results in my normal value. And Milad, I have followed a particular mechanism. I have supplied information from September 2024 to September 2025, following a particular methodology to come to my normal value, which includes the ethane, the related party ethane costs, and this cost allocation. On the at the time of disclosure statements, which is Milad, on the 10th of November 2025 is the first time, Milad, where my cost of production has gone by 73%. The normal value has gone up. Milad, page 20 of my writ petition. I have given
that chart.
Yes, that chart. So, Milad, they have come to that value in some methodology. Now, Milad, they have kept
that has not been
that has, and Milad, these variations which relates to my cost of production, I'm pointing out today to establish that it is essential fact. Yes, I'm just pointing out for the different page numbers. Milad. Otherwise, Milad, the submissions are the same. Now, Milad, briefly I'll state the cost allocation, which was the second issue, Milad, on page 356. And page 357, Milad, bottom part, I have given explanation of my cost allocation. Milad, subsequently on page 360, this is a letter dated May 26th, 2025.
57 and 60.
Yes, sir.
356.
Now, Milad, relevant page is 362, bottom portion.
Yes, 62 you had pointed out in the
Yes, sir. Then, Milad, kindly last come to page 368.
368.
Now, Milad, page 368 is a letter dated June 6, 2025.
Yes.
Milad, over here also, this is the cost allocation I have given for both my product under consideration and product not under consideration. Milad, subsequently, in the subsequent page 369, the division is there.
Yes.
Yes, sir. This I pointed out as essential fact that this constitutes, and we have provided the information. And
You have provided your basis for arriving at the.
Yes.
Very much.
Last point, Milad. Subsequent to the disclosure statement, Milad, the dates, the responses as Equate Petrochemical had submitted, we've also submitted the same date. On the same date's response, because this one day.
Pages, give me the
Yes, Milad. The disclosure statement is on page 444, relevant page 471. This is in volume 4.
471.
Yes, Milad.
Yes.
471, Milad, is the table showing what is the dumping margin.
Yes.
That is it, Milad. Subsequently, my first response on the 10th of September, on the very same day at page 503.
503.
Yes, Milad.
Yes.
Milad, we have requested in the middle paragraph, pursuant to the above, we request you to kindly share with us the confidential calculations of our clients and following. Milad.
Right.
And Milad, the methodology adopted. Now, Milad, the designated authority on the same day again responds to me also with absolute cost at page 506 at absolute value.
So the same thing which was provided there.
Yes. It's at page 506 and 536.
536, 537. Subsequent to that, Manoj, I provided my comments, which starts at page 510. Manoj, on page 512,
Yes.
on page 512, I have highlighted that there's an incomplete disclosure of essential facts and that it causes me grave injury. Manoj.
Sir, will you give me a chart of the
Yes,
pages, relevant pages?
yes.
That will be helpful.
Yes. Manoj, last page I want to show, and then I'll rest. Manoj, on page 517, again, I have highlighted that I have duly participated in the investigation, and it is unfair on their part to come up with a new methodology and not disclose it to me before the issuance of disclosure statement. That is it.
Yes.
Much obliged.
May I reply?
Yes. We are taking the first petition, Mr. Salve.
Yes. Because, my lord, the points on principle are absolutely the same.
Yes, yes. So we are taking this 26130.
Correct, my lord. Now, let me start with the point which we started with, my lord, if I may say so with respect.
Yes.
And that is territorial jurisdiction.
Yes.
I submit, your lordship has not heard an answer to that point which would meet the legal test. And let me tell my lord why. My lord, citing judgments which relate to people carrying on business in India doesn't help. My lord, the people who are before your lordships, unlike that first Dhansari who was here, who I could at least understand, said that they carried on business. The people who are here before your lordships are foreign exporters. And, my lord, these people do not carry on business in India. Now, they are exporters. Their exports may land in Calcutta. Their exports may land at the Mumbai docks. Their exports may land in Gujarat. Their exports may land in Kerala. Their exports may land anywhere where a ship. Their exports will land where a buyer chooses to get them. So, my lord, citing cases where the court says your business in India will be affected or your business based in a particular city will be affected is no use. For the simple reason, my lord, these people don't have any business in India. If nobody in India exports their goods, they have zero business. They are foreign exporters. They are not Indian importers, a point which they have tried to elide over. Now, my lord, if this is correct, then, my lord, please see where do we end up with this. Your lordships were shown a judgment of the Supreme Court. And if your lordships turn up that judgment again, because, my lord, this is the judgment of the Supreme Court, so whatever, if there is any position which is inconsistent with this by
Which
a
one?
judge,
Which one, Mr. Salvi, which judgment?
the Adani case, my lord.
Adani case.
Yes. And your lordship will find that
Yes.
it's at page 44 of the compilation, I believe. There are two important points which I made, my lord, and again your lordship has been, if I may say so, dragged into the merits of the case. At a premature stage, because, my lord, let me make this point very clear. At least my client is concerned. We have, my lord, challenged territorial jurisdiction. And your lordship was kind enough to indicate that your lordship will hear the maintainability. Now, my lord, if your lordship holds the petitions are maintainable, there are a number of these allegations made. So-and-so thing is not shown, so-and-so something was not made available. All this has to be replied to on affidavits. We haven't reached that stage. So, my lord, all these arguments, frankly, are provided your lordship saying that your lordship is going to entertain this petition. So, I think we are getting a little ahead of ourselves looking at all this. I'm back with where I began, my lord, the two big points which I had made. Territorial jurisdiction and complete alternative remedy. And let me, my lord, focus only on those 2 points. Territorial jurisdiction, my lord, I had cited Adani. And if your lordship just sees 3 paragraphs again, to which your lordship has not heard an answer. Paragraph 5. Having considered the arguments addressed on behalf of the parties and having perused the records, we are of the considered opinion that the question of jurisdiction should be decided by us before going into the merits of the case at hand. In fact, we feel it would have been more appropriate in the facts of the case if the High Court had proceeded under 14 Rule 2 of the CPC by deciding jurisdiction as a preliminary issue instead of deciding the case on merits. But I relied on this to persuade your lordship to hear this point first. Now, my lord, look at the point which is being urged by my learned friends. That point is raised and expressly rejected. If your lordship turns para 13 is the submission which I want to show. In spite of the above named facts, the respondents plead, as per the plea raised by them, the special leave application, following facts give rise to the cause of action, territorial jurisdiction of the court at Ahmedabad. They carry on their business of export and import from Ahmedabad. The orders of export and import are placed from and are executed at Ahmedabad. The credit of the duty claimed in respect of exports was handled at Ahmedabad since export orders were received at Ahmedabad, payments were received at Ahmedabad. Non-granting and denial of utilization of the credit in the passbook will affect the business, and the respondents have executed a bank guarantee through their bankers at Ahmedabad and a bond at Ahmedabad. These are the facts. The next para says, although it is contended in para 16 of the application that the appellants have their office and the contention has not been pressed, it's clear none of the appellants devour the fact we take into consideration the other facts enumerated here and above in support of the cause of action pleaded by the respondent, and it is seen none of these facts are in any way connected with the relief sought for by the respondents in their civil application so as to constitute the cause of action at Ahmedabad. My Lord, pause here for a minute. What is the relief, my friend? See, there is a recommendation of the designated authority which has to go to the central government. The central government may, on the basis of this recommendation, impose a duty. So all this is going on in Delhi. The recommendation has been made in Delhi. The central government will act in Delhi. Nobody is acting in Calcutta. There will be no duties imposed in Calcutta. And they are wanting your lordship to set aside this order and send it back so that various, according to them, procedural lapses which have taken care are addressed. But today, there is an order written in Delhi which is to be given to an authority in Delhi who will take the recommendation and may not impose the duty. We are talking of imports being affected. Today, there is no duty. This order doesn't impose a duty. This order is a recommendation to the union government. And that recommendation from Delhi to the union government in Delhi by a foreign exporter whose exports may land in Calcutta, may land somewhere else. To say that, my lord, he has affected in the jurisdiction of Calcutta is completely far-fetched. And that is exactly what is said, my lord. Please turn to para 16. It is clear from the above constitutional provision that a high court can exercise this jurisdiction in relation to territories within the cause of action, whole or part arises. This provision has come up for consideration in a number of cases. And it would suffice for us to refer to the observations of this court and ONGC. Under Article 226, High Court can exercise power to issue writ order or direction for the enforcement of any fundamental rights of the Constitution or any other purpose, wholly or in part had arisen within the territories in relation to which it arises. Now, what is where did this cause of action arise? Where the calculations were made? These people are sitting in Kuwait. The calculation is made in Delhi. The cause of action arises in Delhi. How does it arise in Calcutta? Saying that if the cause of action be what it is, if the recommendation is what it is, and the recommendation is accepted, and if an import lands in Calcutta, then the importer, not the exporter, then the importer will have to pay this duty. But Dhanseri was an importer. These are exporters, they don't pay duty. But how does it affect them? It affects them because their goods become more expensive where? Their goods become more expensive in India. Wherever you import. This is not a Calcutta-based duty or a Bengal-based duty. Please see, Malad, the rest of that paragraph. The expression cause of action means the bundle of facts which the petitioner must prove if traversed to entitle him to a judgment. Malad, what are the bundle of facts your lordship has heard? My learned friends have said, I submitted information. Where? In Delhi. The authority asked me for an explanation in Delhi. I gave an explanation in Delhi. This explanation, the authority should have, in his order issued in Delhi, given me clarification. The authority sitting in Delhi did not give me a clarification, etc., etc. That's all that your lordship has heard. Where are all these causes of these bundle of facts? Has your lordship heard today or the other day a single fact which the petitioners rely upon, which took place in Bengal? Not one. Because we are at the inquiry stage. So the test is the bundle of facts which you need to prove. And if traversed to entitle him to a judgment, therefore determining the objection of lack of jurisdiction, the court must take all the facts, what I'm reading from that passage, pleaded in support of the cause of action, considering, albeit without embarking into an inquiry of the correctness of the facts. It is seen from the above, next parameter, that to confer jurisdiction on a high court to entertain a writ or a civil application, the high court must be satisfied from the entire facts pleaded in support of the cause of action that those facts constitute the cause so as to empower the court to decide a dispute which has at least in part arisen within the jurisdiction. Please mark these words, my lord. The dispute should arise within the jurisdiction, not that I will be affected, my business will be affected. It is clear from the above judgment that each and every fact pleaded by the respondent does not ipso facto lead to the conclusion that those facts give rise to a cause of action within the territorial jurisdiction, unless those facts pleaded are such facts that have a nexus with the list that is involved in the case. Facts which have no bearing on the list or the dispute involved in the case do not give rise to a cause of action so as to confer territorial jurisdiction. If we apply the principle, we see none of the facts pleaded in para 16 of the petition falls in the category of bundle of facts which would constitute cause of action giving rise to a dispute. As we have noted earlier, the fact that the respondents are carrying on the business of export and import, or that they are receiving the export and import orders of Ahmedabad, or that documents and payments for exports and imports are made in Ahmedabad, has no connection whatsoever with the dispute that is involved in these applications. Similarly, the fact that the credit of duty claimed in respect of exports that were made from Chennai were handled by the respondents from Ahmedabad have no connection whatsoever with the actions of the appellants impugned on the application. The non-granting and denial of credit in the passbook having an ultimate effect on the business of the respondent in Ahmedabad would not, in our opinion, give rise to any cause of action to a court in Ahmedabad to adjudicate on the actions complained in the applicants. So, my lord, this test that it is my business is affected is the wrong test. The test is, where do the dispute on facts arise? My lord, one doesn't have to go very far. If your lordship turns to the petitions, I'll just, because my lord, we must argue this on a demerger. Your lordship will assume everything they say is true. And please pick it up, my lord, from para 9. Unfortunately, my scan is cut, so my lord, I don't have the full page number.
Para 9, page 7.
Yes. The petitioner states that notification also invited comments from your petitioner, etc., etc. Respondent issued notification, so and so. Respondent subsequently issued a notification. All right, man. So, invitation of questionnaire from Delhi. Your petitioner states that it actively participated in the investigation and submitted its comprehensive questionnaire, the responses of 25 December. Where did it submit this? In Delhi. Your petitioner states that in proceeding before respondent 1, confidentiality, etc. is maintained. Then, my lord, please turn to para 11. On 8th April, respondent issued a verification request from Delhi to Kuwait. The question raised pertain to so and so. Please don't bother about the detail. Then the last two lines. The petitioner filed a detailed verification response on 21st April. Kuwait to Delhi. Then, my lord, para 12. Your petitioner states on 9th April, respondent issued a verification request. Delhi. Para 13. Your petitioner states that parallelly an oral hearing was conducted by respondent 1, Delhi. Para 14. On petitioner states on 2nd May, petitioner filed sales verification response. Where did he file? Delhi. Para 15. On 23rd May, respondent 1 requested clarification. Delhi. And para 16 is where he says the trouble starts. Please read that, Madam. Your petitioner states on 28th May, respondent directed your petitioner to undertake a desk verification. During desk verification, respondent not verified the cost reported by a petitioner. The questions pertain to cost verification filed by a petitioner included questions, directions, again seeking reason for allocating. Another key question was why your petitioner had taken double credit, etc., etc. And then, my lord, your petitioner, through the submission of 6 June and clarification, addressed all the queries. My lord, this whole exchange is between Delhi and Kuwait. And he said, I have given all this reply. Para 17 talks of a second oral hearing. Para 18 talks of further representation. My lord, it will only waste your lordship's time. Your lordship can take it unsurprisingly. Not a single relevant fact relates to West Bengal. Para 24, my learned friend relied on a table. Where did he give this table? He prepared it in Kuwait and sent it to Delhi. And what is his ground? Para 32. Your petitioner states that the impugned final findings issued in Delhi are vitiated by procedural irregularities. Now, my lord, let's walk through this. A, non-disclosure of essential facts. Where were these to be disclosed? Delhi. He is sitting in Kuwait. My lord, if the disclosure had been made in Bengal, he is saying, how do I know? I'm interacting in Delhi. So, non-disclosure of essential facts, bundle of facts, he needs to prove. He needs to prove that there was non-disclosure in order to win. Where did this non-disclosure happen? Delhi. Arbitrary and inflated costs taken. Where did this happen? In Delhi. Injury analysis selectively done. Where? In Delhi. Erroneous causation and failure to establish link. Where? In Delhi. Non-application of mind. Where was the mind applied? In Delhi. So, my lord, if he has to prove A to F, as Supreme Court said, these are the bundle of facts. If your lordships accept these, your lordship will allow his writ. This is the bundle of facts he needs to prove. Please show one of these which has the most remote connection with any place other than Delhi. Your lordship will find none. So, my lord, we ask ourselves the wrong question. Oh, I may have some imports. I had one import. That import may have landed in Calcutta. That's not, that Supreme Court said all that doesn't matter. Cause of action under Article 226(2) is cause of action must arise. And my lord, all of us carry this misconception. Cause of action means some injury being caused. Depends, my lord, what the petition is for. If he was given a notice of detention in Bengal, you say the notice of detention is my cause of action. If there was a demand raised in Bengal, then you would say that demand is part of my bundle of facts. Today, there's nothing. There is a recommendation made in Delhi to an authority in Delhi. So, my lord, I submit your lordship has not heard any answer to this. Now, my lord, my learned friend realized on a judgment of a learned single judge, my lord, which doesn't really help. Because Adani's judgment is not considered there. Now, my lord, changing tracks. What is the nature of this inquiry? Because all these points, my lord, which are being made, you can go and appeal. What is being made before my lord, as we say, the classic division, your lordship is on the decision-making process, not the decision. If the decision is wrong, you have an appeal on facts and law. Your lordship is examining the decision-making process. And your lordship would have noticed that my learned friend's submissions went very light on the rules and the rules as they are applied. My lord, there is a judgment of the Supreme Court I want your lordship to see. It is called Designated Authority versus Holder Top. So directly on the subject matter. I believe a copy is being made available to my lord. This is, my lord, 2000 volume 6 SCC 626. I don't know, it's some strange law report which my learned friends have picked out. And my lord, what is important is this came out of an appeal from the tribunal. Please see para 4, my lord. On the conclusion of the public hearing, the authority by the final order confirmed its finding.
Para 4.
Yes.
Yes.
On the conclusion of the public hearing, the authority by the final order confirmed its preliminary finding in the question of dumping as well as anti-dumping duty. This finding of the authority was also accepted by the central government by its notification of so and so, and accordingly anti-dumping duties were imposed. During the course of inquiry, the authority held that in spite of the demand made by it, the respondent had failed to furnish necessary information in regard to the export price of the catalyst to third countries, which failure significantly impeded the investigation. Here, my lord, they refused to show an agreement under which they were sourcing their raw material. And they said this is confidential because this is from a related party. Consequently, the authority determined the normal value of the catalyst based on best judgment assessment. But your lordship is dealing with the best judgment assessment case. Being aggrieved, the respondent filed a statutory appeal. The tribunal urging the following points, your lordship can reject that. Para 7 is important. However, in regard to the next ground of the 9A as the determination of the value, the tribunal came that the anti-dumping duty was exporter and exporting country specific. On the foundation, tribunal held 9-1. You see, there were 3 options. Find out comparable price like for like article. If the exporter is not having a domestic market, then his price on the article to a third country. In the absence of such an export price of a specific exporter to a third country, find out the cost of production in the country of origin incurred by the exporter and add it to the administrative price. That's what, in fact, was done here. The tribunal held that since anti-dumping duty in export was specific, the price of a similar item article manufactured by export manufacturer cannot be the basis for finding out the above value. Then, my lord, the submissions begin from para 10. Please see the contention in para 11, my lord, which is upheld. On behalf of the appellant, it is contended before us that the authority was justified in relying on comparable export price in the background of the fact that the respondent was withholding the most relevant evidence and in a way compelling the authority to proceed with the normal determination of normal value based on selective evidence produced by it. The respondent supported the order of the tribunal by contending that its cost of manufacture of the subject catalyst was sufficient material as contemplated, and therefore the authority was not justified in placing so on. In the instant case, the authority proceeded on the presumption it had no obligation to accept per force the material submitted by the respondent to establish the normal value concerning the articles, etc. Then, Marat, the statute is set out. And if your lordship sees at page 29, up just above para 14, the rule, my lord, which I cited before, my lord, except in cases referred to in sub-rule 8 of 6, the designated authority shall, during the course of investigation, satisfy itself as to the accuracy of the information supplied by the interested parties upon which its finding is based. Your lordship remembers, my lord, I strongly relied on this rule. From a perusal, it is clear from the statute is given sufficient guidelines to be adopted in the process of determining normal value. To some extent, these guidelines have been placed in a preferential sequence. For example, if acceptable materials available in regard to comparable price in the course of trade in the exporting country or the territory, normal value will be on that basis. If the material is comparable, price is not available, authority has been given under 9A1, C2, A and B. The choice is between the comparable representative export price and the cost of production. Therefore, question for our consideration is whether the investigating authority has the discretion to reject the material produced by one party to the proceeding in regard to the alternatives and prefer any other material. As noticed above, the authority has proceeded on the basis it has the discretion to reject the evidence. The tribunal held that the authority has no such discretion in view of the fact that anti-dumping is exporter specific. It would be appropriate to extract the wordings of the tribunal. Then not we skip that. Please see the next paragraph. We see with respect, we are unable to accept the finding of the tribunal from a careful reading of 9A of the Tariff Act and Rule 6 of the rules. This clear statute does nowhere put a restriction on the investigating authority. On the contrary, a perusal of the provision shows that the normal value will have to be determined with reference to comparable price. Comparable price can only be with the reference to the price of similar articles sold in similar circumstances, etc. By holding anti-dumping duty to be exporter specific, the tribunal could not have restricted the scope of investigation only to the materials produced by a party to whom an investigation is being conducted. Please mark this, Manoj, this is very important. So this point that I gave you a calculation, you rejected my calculation, you took some other figure, this is not the approach. Such an interpretation of the statute is wholly contrary to the very scheme of the statute. Is to be noticed, statute is given much wider power than what is understood, as is evident from the language of 9(1)(c), and please mark Rule 6(8) of the rules. As noticed above, 6(8) of the rules specifically empowers the authority to record the finding on basis of facts available to it in cases where an interested party refuses access or otherwise does not provide the necessary information to it. That apart, the use of the word sale and the like in comparable representative price also indicate the statute intended. While the normal value, the authority has discretion to rely on such material as is available, which reflects comparable value, meaning thereby the authority is not, please mark these words, Manoj, the authority is not bound to look into the material produced by the interested party. Therefore, any argument which restricts the discretion of the authority in the area of appreciation of evidence on the ground that the anti-dumping duty is manufacturer specific will have to be rejected. Para 17 is also very important. Completely answers everything they've argued. In the instant case, the authority has come to a specific conclusion. The respondent preferred not to disclose the details of the export price of the concerned catalyst to an appropriate third country, even though the same was available with the respondent. It also noted that the reasons advanced by the respondent for not furnishing the information are not worthy of acceptance. The authority has further observed that withholding the information which the respondent was bound to have to disclose under the statute, the respondent has, please mark these words, not cooperated with the investigation and has called impediments in the determination of normal value. We are of the opinion that the authority was justified in proceeding to determine the normal value of the subject catalyst on the best judgment assessment as contemplated under 6A. Now, my lord, what has happened in our case? Your lordship sees rule 6.8, my lord, I had shown, which is also your lordship has read a minute ago. And I showed my lord the order. The order is based on rule 6.8. If your lordship turns back, my lord, the order is of 23rd September, my lord, it's at page 60 of the paper book, volume 1.
Yes.
Para 158 and 159. One has to only read these two rules, Mara. That's the end of the procedural challenge. He can go to the tribunal in appeal. He can show they took a wrong figure. They should have taken 5. They should have taken 7. That's not the decision-making process. So that's very clear. Your lordship is pleased to turn. Para 158.
Yes.
And this has not been addressed. During the course of desk verification, the authority found several inaccuracies and deficiencies in the Equate Group's response. And as such, the cost of ethylene captive import for the PUC was significantly higher and lower. In the original response, Equate had claimed double deduction for byproduct credit with no reasonable justification. Freight reported by Equate Group for exports was revised. Further claim for inventory adjustment in the appendices was revised. Thus, substantial revisions were made during verification, which the authority has taken into record. I will show, my lord, in 2 minutes' time, the 3 letters which they are relying on, which Mr. Khaitan read, shows that this is true, that they revised figures. Now, my lord, look at the next para, which actually is the Haldor-Topsøe principle. The authority has determined cost of production based on revised response submitted by Equate to the extent the same could be verified. Those words are critical. To the extent the same could be verified. It is noted that Equate and TKOC purchase raw material for production of captive unit ethylene from the related party, Kuwait Petroleum. However, the same was not reported by them in Appendix 10 submitted in the original response. Further, it was noted there was a significant difference in ethane purchase reported by the 2 producers of Equate. Equate refused to provide copy of feedstock agreements with KPC to substantiate their claimed purchase price, mentioning that the agreement contains highly confidential and commercially extremely sensitive information and cannot be submitted. The authority notes that under Rule 7, confidentiality of information cannot be claimed qua the authority. On account of refusal of information, the authority has relied on best information available on record to compute the cost of production. Please stop here. If this is what he has done, now the writ petition is, but you didn't tell me which figures you are going to take. In a best judgment assessment, in a 226. Let them go and show the tribunal he has made a mistake. But this is what he has done, and Haldor-Topsøe says that if you withhold information, you run the risk. So where is the question of his disclosing now? He is making a best judgment assessment. And this is allowed by 6.8. So, my lord, this is completely, if I may say so with respect, misconceived. The whole challenge on natural justice is misconceived, which is my second point. My lord, just 2 letters to show that what he's saying is correct.
Mr. Salve, I have a division bench at 3.
No, I'm done, my lord. I'm done.
I'll have to rise.
I've finished, my lord. 5 minutes if your lordship have. Otherwise, I can do it.
I'll have to go to a different building for sitting there with the.
No. Whenever your lordship has time, my lord.
When can we come back next? Since Mr. Salve is continuing, we can have it on any day with tomorrow. Yes, Mr. Salve.
Tomorrow we go to 2 o'clock tomorrow, my lord. Same.
Tomorrow,
like
2 o'clock, I have a different matter fixed.
Oh, I see.
2 o'clock. Oh, no, I don't know. Or on Monday.
Monday, 2 o'clock, my lord.
Monday, Tuesday, 2 o'clock instead of Tuesday.
Tuesday, 2 o'clock is fine. Absolutely fine.
Tuesday, 2 o'clock.
Perfect, man.
Tuesday, 2 o'clock. Heard Mr. Salve, the senior advocate appearing for the respondent number 3 and 4. Respondent number 3. Full stop. For continuation of his arguments, list this matter once again on a Tuesday at 2 p.m. Or actually, same, same. Thank you.